Hello and welcome back. I want to first of all apologize that I gave you some misinformation at in the last PowerPoint for Chapter 1. I thought when beginning this process that I would be able to use a software program that allowed me to add one or two multiple choice questions in or to the PowerPoints themselves. It appears that YouTube does not allow me to upload software that includes that particular option, so I wasn't able to do it. In any event, we are continuing with Chapter 1, and in this particular instance we're going to be looking at some of the different approaches that can be taken when one wants to study different criminal justice systems. Your textbook identifies three of these: the historical approach, the political approach, and the descriptive approach. I'll briefly mention the first two. We'll be highlighting the descriptive approach, so we'll spend more time on that one. The historical approach is interested in looking at criminal justice systems in a way that will allow us to basically learn from history, to determine what kind of things have happened earlier, either in the country that we're particularly concerned about, or other countries that might have some bearing on the United States, for example. So the historical approach is looking at criminal justice systems as they have operated in the past, seeing how different kinds of events affected those criminal justice systems, and trying to learn what we might be able to from those historical incidences or those experiences. For example, in the past we have had in the United States time periods when we've had prison overcrowding. Even if this had been 20, 30, 40 years ago, the way that the system responded to those overcrowding situations are things that should be helpful to us in trying to determine what we might do today with prison overcrowding conditions. Similarly, other countries have had, in different time periods, overcrowded prisons, to stay with that same example, and they might be able to look at the United States and see how our response to those overcrowded conditions could be useful to them as well. So basically the historical approach is looking at those earlier experiences, whether they are in the country of particular concern or other countries, and to see how those other experiences were handled and what we might learn from those. The political approach looks at a nation's criminal justice system and how the politics of that system or that country have influenced the system. Those politics include not only the country's legal tradition and the politics of the country itself, but how the interaction amongst various countries or other nations might influence what happens in a particular country. We see this example in contemporary times when looking at the wars in the Middle East, for example, and when the United States was trying to help build new criminal justice systems in Iraq, for example, then that was being influenced by not only that country's criminal justice system, but also by our own criminal justice system. Those kind of political approaches are obviously very, very important and necessary to understand, but again, for reasons I'll mention in just a few moments, not the particular approach being taken in this book. Instead, we're going to be using, not only in the textbook, but in the class itself, the descriptive approach. And under this particular one, the concern is with how a country's justice system is supposed to operate. And this is a key point to make, because we all understand that just because something is described as presumably operating in a particular manner doesn't necessarily mean that it's going to. However, in order for us to basically, or to have a base for understanding a country's criminal justice system, we need to at least understand how it is designed to or supposed to operate. And so we're going to spend a good bit of time trying to learn about the criminal justice systems in other countries in terms of this descriptive account, what they are designed to do, how they were designed to be set up. We're going to be doing that with an open approach, an open mind, keeping this tendency or this situation in mind where the police, for example, are designed to operate in a particular manner. But we all know that, in fact, in any country, the police won't always abide by the particular rules and regulations that were set up. But again, we have to start somewhere. So this descriptive approach is the one that we'll be using, trying to understand how things are supposed to operate, what the main components of the justice system are, who the primary actors of the system are, and those are all going to be things that we can keep in mind as we are moving forward and trying to understand the different criminal justice systems. This descriptive approach, as I said, is the one that we're going to be highlighting here. This approach tries to describe the similarities and differences in the various criminal justice systems that we might be of interest in or might be of interest to us. There are two approaches that we can take in describing these similarities and differences. One is called the functions and procedures approach, and when using this approach, we're interested in describing how various jobs are accomplished. The institutions actors approach is one which emphasizes the particular responsibilities of the actors who are charged with accomplishing different jobs and the agencies and institutions that are set up to carry out the different procedures. The institutions and actors approach is one that we're going to be looking at more fully in other chapters. So right now, just in this chapter, we're going to give an example of the functions and procedures approach, just to give you an idea of how this one might be set up. And the particular example that we're going to use, as your textbook does, is how defendants can be protected from abuse of their accusers, government agencies in this particular instance. In other words, what kind of protections are there for pretrial detention in different countries? And again, this is just an example of how the functions and procedures approach could respond to the very particular question of pretrial detention. It could, of course, been any aspect of the criminal justice system that we want to compare across countries. We'll just use pretrial detention here. And your textbook looks at the United States, France, and China. I won't go through this in great detail since you can find the same information in your textbook. But we will hide at least a few of the points that are mentioned there. If this was a more interactive kind of setting, I would ask you to think about how long you believe any country should take before they formally charge an individual. Is it something that should be done pretty quickly, within a couple of hours? Should the police be allowed to have several hours or days before they have to formally charge somebody? Well, in the United States, as you may know, the police may detain suspects for a limited time for what is called an investigative stop or an investigative detention. Any kind of prolonged detention, the person has to be put under formal arrest. Now, the United States Supreme Court has not set specific limits. Instead, simply have said in their various rulings, detention should last no longer than is necessary. The police, essentially in the United States, this has been taken to mean that anything longer than 48 hours without having some kind of independent review or judicial officer is regarding the legality of the detention is seen as being inappropriate. So even though the Supreme Court hasn't set time limits, the general approach has been to take 48 hours as being a reasonable amount of time for the police to have made a determination regarding whether this person needs to be arrested or not. In France, just as a point of comparison, the approach is one depending more upon how recently the offense has been committed. For example, for those that have been occurred within the preceding 8 days, the police can detain a suspect without having any kind of a warrant for 24 hours. They can detain, the prosecutor can extend that detention for an additional 24 hours as long as the prosecutor believes that there is additional weighty evidence that supports guilt. Anything beyond 48 hours, however, the police must turn the investigation over to an investigative judge who happens to be a member of the judiciary. for any kind of temporary detention, but only, as it points out here, if the alleged crime is punishable by more than 2 years and the suspect is a flight risk, or the pretrial detention would be inadequate. Now, these are interesting contrasts just between the United States and France in terms of this function and procedures approach. In the United States, 48 hours without any particular concern for what the punishment is for the charge that the person is facing, and without any real involvement of the judiciary prior to that time. This makes it look like in France the judiciary gets involved earlier, after just 24 hours, and in fact that is true, but it's also important, as we'll see later chapters, that in France the idea of the prosecutor is interpreted a little bit differently than what we have in the United States. In France, there are investigative judges who are part of the judiciary, but they really work very closely with the police. And because of that, this idea of the prosecutor extending detention isn't necessarily as far removed from the police role as what we might think. The information about the investigative judge, as I said, will come up to again a little bit later in the textbook. Take a look at China, however, and here we're interested in how citizens or those people accused of a crime in China can be handled by the police. And as you'll see, the police may detain the suspect up to 3 days when there is one of 7 conditions that exist. Your textbook identifies those 7 conditions. Just as a couple of examples, if the police believe that a crime is about to be committed, is now being committed, or was just committed, that's some of the conditions that can be set up. And under those situations, the police can detain the suspect for up to 3 days. Under special circumstances, which in the law are rather undefined, the initial period could be extended up to 4 more days. Then for major cases, it could be up to 30 days. After 7 days, or if it's a major case, after 30 days, the police must get permission for a formal arrest from the prosecutor, and that prosecutor has another 7 days to decide. Well, the point here is, of course, that in China, essentially on their own authority, the police may detain pretty much anybody for up to 37 days. Quite a bit different from either the United States or France in terms of how much control or how much influence China has been given by the authorities. So this is just one example of how 3 different countries can be looked at and compared in terms of their similarities and differences regarding the functions and procedures for how the police system operates, or the detention system in this particular example. As I say, that's just one of many. Your textbook is going to be highlighting a few of those other kind of differences as we get into each of the chapters. But your textbook is also going to be using more of the institutions actors example rather than the functions procedures. Under the institution and actors example, the particular institutions are going to be looked at. So chapter 6 will look at policing, chapter 7 will look at the court system, chapter 8 will highlight the corrections process. And in each of those instances, we're going to look at the institutions themselves, police, courts, and corrections, and also the various actors within those institutions, police officers, attorneys, etc. We'll start getting into that a little bit later as we get into chapter 6, but first we'll be looking at a few more chapters, chapter 2, 3, 4, and 5. Each of which begins introducing more particular aspects or specific aspects of the comparative criminal justice approach. Thank you for your attention, and I will be speaking with you again in chapter 2.